Welcome everybody to the March 2015 web share on using international law in campaigning. My name's Michael Hayworth. I worked as a campaigner with Walk Free and formerly as a crisis campaigner with Amnesty International. I'm based in Toronto, Canada. I have a Bachelor of Laws, a Bachelor of Business, and have been working on campaigns and advocacy for about 10 years now. Today we're going to take you through a few things in this web share. We'll start off, of course, with a few definitions around what campaigning is, and just so we're all on the same page when you hear me talk. We'll then go and look in campaign analysis, because I think the work that you do before you start the campaign is probably most critical to how you can engage with international treaty mechanisms, and in particular how you define problems as human rights problems. We'll then look at using treaty mechanisms, what treaty mechanisms are available and how you can get involved in those. Using and supporting survivors as advocates, or rights holders as advocates for their own cause within the international treaty sphere and within international law. And then finally, a few do's and don'ts about how we can use human rights in your campaign messaging. So, firstly, quick definitions. A campaign, it sounds silly, but we all campaign in our own different ways. When I talk about campaigning in this particular context, I'm talking about everything your organisation does to create change. So that might be an advocacy program, it might be some online petitions, it might be protests or whatever it is. It's the whole group of activities that make up your campaign to create the change or to end slavery. We then talk about analysis a bit, and I have a section in this particular web share about pre-campaign analysis. And basically all I'm talking about there is how you define your issue, how you define solutions, your critical paths, how you map out the different change, and how you might look at your targets and do research on those guys. The strategy itself is, probably an integral part of your campaign plan, and it's really the document that describes how you're actually going to go about achieving the change that you want. What sort of activities, what sort of tone, and what sort of direction you're going to take. And finally, for definitions, the last one I have in there is tactics. So a tactic might be sending out an online campaign or an online petition, or it might be attending a meeting of the UN, or attending a committee hearing. It might be writing a shadow submission, or it might be attempting to get a meeting with a government minister. We'll jump right into campaign analysis, and I've got a few dot points here of what I think are some of the sort of core elements of campaign analysis. It's not actually critical that you have all of these, or this isn't an exhaustive list, but these are some really good starting points for what you might want to include in your campaign analysis. We're going to focus a fair bit on the human rights problem in a second, but I just want to talk through each of these so it helps people sort of contextualize where we're at and where this document, where your campaign analysis would happen in terms of the timing. So this should really happen before you start campaigning. It should happen each time you try and change the direction of your campaign, or each time you try and look at a new thing that you want to change, or a new issue you want to get involved in. And it's a pretty simple sort of research document. I've written a number of these over the years, and they don't necessarily need to be too formal, but they need to be really thorough. The first one that you need to look at is your aim, describing in a really clear sense why you're doing what you're doing. The second point is the problem, and in this case we call it the human rights problem to tease it out. But really looking at, what is the issue that you're trying to solve? thirdly, solutions, and there are some really interesting ways people do solutions analysis. Some people put it in a matrix to look at a whole lot of different solutions against a lot of different criteria. In some issues, like slavery, the solution can be very straightforward. In other issues, it can be very, very complicated. Your SWOT stands for strengths, weaknesses, opportunities, and threats, and your PESTLE is the political, economic, social, technological, and legal environmental analysis that you go through. And those things are really helpful tools, I think, and they've been around for quite some time, but again, really useful in campaign analysis. A power map is about identifying all the different players and all the different decision makers inside your issue, and who might be influenced by who. And in terms of engaging with international law, this is another particularly important one. If you can identify that a particular decision maker would be very, very heavily influenced by what the UN might say, or they might be very heavily influenced by what another country might say, that other country should really go on your power map, and you should look at, how supportive they are in terms of your issue and how much influence they can have over your target. Your target and influencer analysis is also really important for this, because you might have a country who has a particularly high prevalence of slavery. Take Mauritania, for example. And that country might have an international donor like France that donates large chunks of aid money into that country. Even though the primary target might be the president, there might be a really substantial and influential relationship between the Mauritanian government and the French government, or another government in the region that might be friendly. And the final point here, of course, is audience analysis, which is really more critical for your public campaigning activities rather than your engaging in international law. Let's look now at the human rights problem and why it is so critical to being able to engage in international law. I think the first thing to be said is international law itself is a body of treaties, and when it comes to these treaties, they're looked at by different committees or different reporting bodies, depending on what treaty you're concerned with. But all of them, regardless of whether we're talking about children's rights or women's rights or civil and political rights, all of them come back to this fundamental concept of a human right needs to be breached or has failed to be realised by a government. And that's why it's so important when you talk about the problem, and when we define the problems that we're trying to resolve. From the very start, we define them within a human rights framework. So what that means practically is whilst we might describe the problem to a member of the public as horrific or outrageous, or it was a terrible story, and use that sort of personal narrative, in the international law sphere, really we want to be able to say that this particular action happened to a number of people. For example, a high percentage of women experience violence. That breaches their right to physical and mental integrity and to live a life free from violence. And the government has failed to do something about it. And we'll get a little bit into that framework in a second when it comes to slavery. We also, in all of this, do want to be as specific as possible. In the international law sphere, we really need to be able to identify specific instances of our issues, specific cases. We need to have specific human rights that are breached and actions by the government that have failed to resolve the situation to demonstrate that a breach has in fact occurred. Let's look now at this framework that I briefly alluded to previously. Basically, we want to be able to do three things, and I apologise for the slide there. It has the formatting a bit broken. But firstly, what we want to be able to do in defining a problem is to be able to state the facts. And it's as simple as saying that 100,000 people are held in conditions similar to slavery in this country, as a very broad thing. But where you guys have huge amounts of knowledge about the issues that you campaign on, I'm sure that you're going to be able to state the facts of the matter very, very succinctly, but also in a lot more depth and detail than I can in this very, very broad example. Once we've sort of stated the facts, what we need to then do is go away and look at the rights. And for this one, I obviously pulled Article 4 of the Universal Declaration of Human Rights, which says that nobody shall be held in slavery or servitude. In this very simplistic example, I've really just pulled out, what is a very common sort of part of customary international law, the UDHR, but there are also going to be specific sets of comments by committees, general comments or specific decisions by the perhaps by the International Court of Justice. Now we've got the International Criminal Court having handed down some decisions, and more to come in the future. Really, stating the rights is about gathering all that information to determine exactly what the right is, exactly what the standard is, and what the international community has used previously to determine or consider what a particular right might look like in situations. And again, that needs to be really relevant to your facts. There's no point in having a situation about slavery and then talking about another right and pulling as many things in as possible, because you want to keep it as relevant as you can. The third point I'm going to make on that is that, on stating the rights, is that you really need to be aware that you can have one situation or one action that happens to a group of people that will violate multiple sets of their human rights, depending on what you think is going to be the most influential set, or what you think are the most critical and important. I'd list those rights right up the top, and then do the ones that are sort of not so impinged down the bottom. The third one in this particular framework is applying the rights to the facts, and I think this is probably the most critical and the most difficult of the three steps in terms of defining a human rights problem. Once you've said that this many people are held in slavery in this country, once you've said that Article 4 of the UDHR prevents people from being held in slavery and gives them a right to not be held in slavery or servitude, then you need to be able to sort of apply it and be able to say that these people are held, and the state is currently failed to do this. The state has currently failed to ensure that people who purport to own slaves are prosecuted, or there's a legal system or a legislative regime in place in the state that isn't working, or police are failing to arrest people. And it makes it much more specific. And when you wrap that all up together in terms of your problem, you've got what's going on, what rights are being breached, and how the factual situation and the rights work together in an applied form. And that particular definition in your campaign analysis can then be used in terms of defining campaign objectives. It can be used in your strategy planning, all of these things, and it makes it a lot easier if you have that from the get-go in your analysis when you come to writing submissions to committees or submissions to governments and that sort of thing. So we're going to leave campaign analysis there for the minute, and we're going to jump in now to using treaty mechanisms. This section's much shorter because it is much more varied in terms of who you might go to. So the steps that I recommend for people in terms of using treaty mechanisms in their campaign, once you've done all of your campaign analysis and you've really clearly defined your human rights problem, you can identify the treaties that contain the rights that are breached. So the Universal Declaration of Human Rights is a classic example. For slavery, there are a whole host of other international treaties, but really the first place that you want to look is you want to look in the core 9 international instruments, and those are things like the Convention on Civil and Political Rights, Economic, Social and Cultural Rights. You want to look at the rights of the child, UN Women's Rights Convention. All of these things you want to go away and look at and determine whether or not any of the rights contained within those treaties are in fact breached. From there, you can go and look at the reporting bodies, so the Human Rights Committee, for example, for ICCPR, or the CEDAW Committee for the Women's Rights Convention. And you need to know about which countries are on those committees, when those committee meets, and then most importantly, look at when the country that you're campaigning on next reports. So, for example, if you were dealing with slavery in Mauritania and that was the country that you were campaigning on, you'd want to go away and say, when is Mauritania next in front of the Human Rights Committee? The other element that we have there now, of course, is the Universal Periodic Review. That has gone through its first round and is currently going through its second round. Universal Periodic Reviews look at all rights in a collective sense and how the country is performing against them. So they're really particularly useful for actually going away and being able to link one issue to several other human rights issues in your shadow submissions. So you should really look at when the country you're campaigning on is next up for a Universal Periodic Review. Once you know which rights, which treaties, which reporting bodies, and when the country is going to have to report to that committee, you then need to go away and look at who's on the committee and see if you can't identify any supportive committee members. Because whilst as an NGO you can make submissions, and there's a process through the UN to sign up to get that status to be able to make a submission or a report into a committee, it is much more effective if you're able to identify a country who's going to be participating in that, identify the person who's going to be sitting on the committee or the diplomats involved, and see if you can actually ask that country to focus specifically on your issue and to ask questions about what's happening with slavery and ask about specific cases. Those can be particularly useful, and particularly useful to feed information to and get recommendations when we talk about how you might, and we talk about in the next slide, how you might actually get some potential outcomes from this process. The fifth and final thing is, of course, to be aware of deadlines for submissions. Be aware of getting yourself consultative status at the UN if that's a path your organisation wants to go down, and be aware of just how long it can actually take to gather all of the evidence and the information that you might want to write into a submission. You've got all that information. and you have pulled a written submission together for your committee, which outlines the various abuses and the human rights that have been breached and the failures of the governments to correct them. You then need to be aware of the potential outcomes of that. And really, this is why I talk about campaign analysis in the beginning of it, because going to a committee hearing and applying a treaty and international human rights law by itself doesn't actually get you very, very large human rights outcomes. It doesn't create a lot of change. What it can do is get a list of recommendations from committee members, i.e. other countries, to the country that you're campaigning on or to the country that's under review. The country that you're campaigning on can then respond to those recommendations. But it's really important to know that none of these are binding and they can in fact be ignored. Going back to what we said in campaign analysis, and particularly around targets and influences and power maps, is that these recommendations are less likely to be ignored if they come from countries that are within the sphere of influence of your target. So for example, with Mauritania again, if recommendations come from countries that give large amounts of aid to Mauritania or are key trading partners with Mauritania, those sort of things ensure that the government is more likely to listen to the recommendations. The next is survivors and rights holders as advocates. And I want to say at the outset that people who have survived, or people who are rights holders in terms of, they have rights and they're currently being infringed, can be the most fantastic advocates, even at the international level, for change. There's a couple of reasons for this: that they've experienced the issue themselves, but also more, and probably more importantly, as the people who hold those rights, I think that civil society organisations generally, have a responsibility to bring them to the forefront, empower them, and allow them to use their voice to talk to decision makers. But it's very, very important that two things occur. The first is that you need to assess any potential harm to the person who might be a survivor or a rights holder because of their involvement in your campaign or their involvement in advocacy. If you have somebody, you might need to provide them with counselling support. You might need to assist them with a whole range of other health issues that might have negative impacts on other members of their family. And also, in some cases as well, they might actually be physically threatened because they've spoken out against the government. So those risks need to be fully and completely assessed. And the next bit of it is, of course, very, very important to obtain free, prior and informed consent from people. And what that means in a nutshell is that you're able to actually go out and explain to survivors who are considering becoming advocates or considering becoming involved in the campaign that these are the potential risks, these are the potential benefits. You need to include them in some of the decision-making processes on your campaign, and you need to ensure that they understand, exactly what the relationship is, what the organisation can do for them, what the organisation can't do for them, any risks involved, and ensure that they, can consent in their own ways. I can't stress that. Can't stress how enough how important that is. Having gotten that free, prior, informed consent, and having a survivor or a rights holder who's there and who wants to become an advocate, having them tell a personal story to decision makers. They know the issue. They can put their voice, and your organisation can help empower them to actually get out there and do a whole lot more advocacy around that particular issue. It can be something very, very impressive to behold, and it might be things like taking somebody who is a survivor and sending them to a committee meeting so that they can present or give testimony about what occurred in their particular situation and how their particular rights were breached. Again, does take a lot of time and investment, but it's something that can be really, really useful. The topic we have to focus on is human rights and messaging. We have spoken quite a bit about defining a human rights problem, taking international treaties, UN committees, and how people report to those committees, and rights holders and survivors. And I wanted to give you a few do's and don'ts about taking some of this stuff and messaging it, because often it can be really quite heavy for the public, and you want to keep your public communications very light and accessible. Some of the things I say as don'ts are, again, things like talking in too much detail about policies or legislations, human rights instruments, or essentially trying to communicate everything. I think I've personally had this, have done this many times, but trying to communicate too much about an issue in one go can sometimes overwhelm people and reduce how effective your public campaigning is. But you do at the same time want to be able to mention rights or basic human rights and talk about it in general terms, tell the personal stories of people affected, or even better, if survivors or rights holders are involved in your campaign, ask them how they would like to tell their stories to people and allow them to do that. But really, focus with your public messaging, of course, on your solution and how you can sort of clearly articulate that. And that last little bit was just a bit of an add-on, because I think once sometimes when we get too far down the international law path, things can get a bit complicated and it can start to mess with your public campaigning. Now all we've got for this particular web share, we'll have a live Q&A session on the 26th of March 2015. And you can also leave comments below this video. As I understand it, none of the questions that you ask me, if you'd like to ask me a confidential question, you can email me at michael@strategyandfield.com, or you can leave a comment here. Again, anything you ask me in the Q&A session won't be made public. Thank you very much, and I look forward to meeting some of you on the 26th of March.